All right, thank you to both of you. A very well argued case. Our next case this morning is case number 2024-2682, Jerome Uditt versus the state of Florida.
Good morning, Your Honors. My name is Whitney Bone. I represent Jerome Uditt, the appellant in this case. I would like to reserve 5 minutes for rebuttal, if possible. May it please the court. We are here today on two issues, but I'm going to focus my time on the first issue, or argument 1A versus 1B. If the court has questions about 1B, obviously I'll take those questions, but I think the crux of our argument is more properly placed on 1A. So we're here because it is the appellant's position that the trial court erred in denying the motion to suppress, and that this case should be reversed and remanded for an order discharging him from prosecution. The primary issue here is whether or not the officer who seized or de facto arrested my client, which was Detective Platter, had the requisite level of information, either reasonable suspicion or probable cause to take the actions.
You don't dispute that Detective Steiner had probable cause to make the arrest if he had done so, correct?
I don't dispute that Detective Steiner, and I briefed this, I don't dispute that Detective Steiner had enough upon my client arriving at the Wawa to make the arrest. I think also Sergeant Kennedy, the supervisor, based on the testimony at the suppression hearing, probably also had enough.
And so they directed Detective Platter to make the arrests, correct?
I think the way I understand it from the record is that this team of 5 detectives, or 4 detectives and the sergeant, they're going to the Wawa with the information that this is an individual, this is his picture, and at this point I guess I'm just talking about Detectives Myers, Schick, and Platter. I'm not talking about Steiner and Kennedy, but that those 3 law enforcement officers have the information that we're going for a traveler, we're going to apprehend a traveler. They have a picture from Scout, which I guess is the chatting application that was used.
And they understood what the traveling charge was.
The testimony at the suppression hearing from Detectives Platter and Myers was that to them, they work all together in this unit for this Crimes Against Children unit, and that to them, traveler meant traveling to meet a minor.
And
yes.
they know Steiner. I mean, they know Steiner.
They work with
and
Steiner.
They know his persona, that he pretends to be a 13 or 14-year-old girl getting into these chats with people, and one of them turned out to be your client.
I think Detective Myers specifically testified that she was aware that generally Detective Steiner used the persona of a 14-year-old or 13 or 14-year-old girl.
So your argument that this doesn't, what Detective Platter did here doesn't meet the fellow officer rule. So what else would have been needed?
I think the issue here is Montez Valaton requires more in terms of probable cause or reasonable suspicion, whether we're talking about a seizure or an arrest. It's my argument it's a de facto arrest, but even if we're going to say it's a seizure at a minimum, you know, that there was more required here than general communications. Montez Valaton from 2017 from the Florida Supreme Court specifically discusses that, you know, we need more than general. And I understand that, you know, the state and then the trial court relied.
Isn't knowledge usually imputed in these cases, though? I mean, each officer is not required to have the specific knowledge that the other officer had. Is that correct?
I don't agree with that.
And I think that's what the state argues, correct?
That's what the state argues. I don't agree with that. I don't think that's what Montez Valaton says. And Montez Valaton obviously cites to Edwards, United States versus Edwards, which is from the 7th Circuit. And it talks about how even when a supervisor has knowledge, Edwards does, that when a supervisor has knowledge, it's not automatically imputed to everybody else.
But that Montez case also cites to United States v. Woods, where they're saying the fellow officer rule typically requires a direct communications link between officers who possess probable cause, Steiner in this case, and the arresting officers, we assume it, for your purposes, it's got to be somebody other than Steiner or Kennedy. All right. This often takes the form of a direct order that the arrest be effected.
I don't even think necessarily there was a direct order here, and I know it's
Well, I mean, they arrested the guy because Steiner said, I have a traveler, here's his picture, he's going to show up in a car with an Illinois license plate, all of which happened.
Well, I think at that point, you know, and I don't think this is the crux of our argument, but I think at that point, you know, prior to them going to the Wawa and prior to the actions being taken by Detective Platter, we have Kennedy and Steiner who have probable cause based on knowing about the chat.
Let's get right to the heart, excuse me, let me get right to the heart of it. So if I'm understanding the thread or theme of your argument, if Steiner would have said to Platter, Myers, and I can't remember the third one, we have a traveler, here's his picture, here's the license plate, Illinois license plate. He told me when I was posing as a 14-year-old he wants to have sex with me and we're meeting at the Wawa. If he had said that last sentence,
That's my argument.
then we wouldn't be having this discussion, well, I guess we could, but you may not,
That
you
is the
probably
crux
wouldn't be
of
as
my argument.
hopeful as you are today.
That is the crux of my argument, that it is not overly onerous, it is not problematic, it's not even impractical for that amount of information to be communicated to the officer who is seizing or arresting Mr. Udit. There's
So
no,
if they didn't say traveler, they just said, I want you guys to go to the Wawa and get this guy. And they arrested him, and they said, I don't know why we arrested him, Steiner told us to. That would be a better argument for you.
for me, yes, I think that would
The
be a better
traveler
argument.
connotates something to the arrestees, saying, I'm not just traveling, I'm just enjoying the country traveling. I'm a guy who has committed the crime for which he was ultimately charged. And so they were on the lookout for that guy because Steiner and Kennedy, not to be confused with our Justice Kennedy, had information that led, as you correctly concede, was probable cause to arrest him for this crime.
I think that the issue here is that Montez Valaton, which I will submit to the court, I don't think is the clearest on this issue, requires more, the opinion says, Justice Kennedy wrote, it requires more than general communications. I don't think what we have here constitutes more than general communications. If this court doesn't agree with me, I think it might be worthy, if you thought it appropriate as well, to submit it as a question of great public importance, because I think I do concede that in Montez Valaton and these other cases, there's discussion about ordering, you know, an arrest to be made, but then in Montez Valaton, what's stated is that there needs to be more than general. I think that it is, to meet the standard of the constitutional requirement for probable cause or reasonable suspicion, there needs to be just a
contextually, though,
smidgen more.
Steiner's there, though. I mean, he's not right immediately at the Wawa. He's across the street, though, right? So this is not, I'm calling in from Jacksonville or wherever they're all from, Sanford or whatever. He's there. He just is not the one. I mean, I guess there actually is some question in the testimony as to whether, and if the judge actually found that Steiner did the arrest, which sort of, there at least is some suggestion that Steiner thought, well, maybe he did arrest him after all, which obviously then we wouldn't be here either. But
Yeah, I think there's some, I would concede that Steiner is in what I'll say is the general area. I don't know that he's within eyeshot. I don't know that he's communicating. I certainly don't think the record reflects that he gave a specific command or Kennedy did, hey, make the arrest of this guy. I think that on this record you have, you know, Platter and Myers who have a picture of a guy, they're told he's a traveler, and then whatever connotation they take from that, I think that that's not specific enough to establish an articulable suspicion or probable cause to justify Detective Platter blocking in the vehicle.
But they know what that means, though. They know he's a traveler committing the crime of traveling to meet a minor for the purpose of having sex. So
I think that's a conclusion, though, and I think conclusions are not sufficient to justify, the level that's required for reasonable suspicion or probable
So if
cause.
Steiner would have said, please arrest this traveler, he's a traveler to meet a minor to have sex,
I think all Steiner had to say, or Kennedy, was, if you see this guy, we have information that he was chatting with Detective Steiner, who was posing as an imaginary 14-year-old girl. He's coming here to meet up with the understanding that they're going to engage in sexual activity. I do not, and I think that's the problem. I don't think it's overly onerous or impractical, even in a situation which I don't see that on this record, where it was like exigent circumstances and it's emergency and they have to act super, super quickly. I think, obviously there was enough time here for that to be communicated. And instead we have a record where Detective Platter and Detective Myers have barely any information about this at all. All they're told is this is a traveler, and they're showed a picture. And then
Can I ask you a question, though? Can I ask you a question? What evidence did you seek to actually suppress? In other words, what evidence was seized or gathered as a result of the arrest?
So I know that trial counsel, I wasn't trial counsel, but I know that trial counsel for appellant had sought to suppress identity, and then also the cell phone was seized, there was a search conducted, and then the cell phone was seized immediately following the blocking in of the vehicle. Put the iced tea on the car, put your hands up, taser out, they get the phone.
Well, how could they had all the communications, right? They also had him coming to Wawa, which was by itself pretty incriminating. So how could identity have been suppressed? Because Steiner was there, Detective Steiner was there.
I don't know that was flushed out very thoroughly on the record in the suppression hearing. I don't think the trial court obviously was really focused on that. Obviously, the trial court was of the opinion it didn't really even need to hear from the state, that it was finding that there was sufficient evidence of fellow officer communications. But I do think at a minimum, if the court wasn't to find that identity was something that was suppressible here, that we have a cell phone, and they take the cell phone immediately after seizing him, arresting him. They take it, they use it, never gets it back. So I think it's the fruits of the poisonous tree. I think
On Judge Carvula's question, you said you were looking for us to discharge him from prosecution. Even if we were to agree with you, the state still has evidence to then go forward on the case, correct?
they agreed this was dispositive with regard to reserving the right to appeal, is how I understand it. So
You're benefiting from that broad use of the term dispositive by the state. I mean, I know we have what Churchill versus State that says once the state says it's dispositive, then that's the end-all be-all of our, we as an appellate court can't second-guess that, although as I think Judge Boatwright's pointing out and Judge Carbula is, this really isn't a dispositive motion. If you threw out the cell phone, you still have other evidence that would readily support prosecuting your client, right?
I don't know if I agree.
It doesn't hurt you to say, yes, that's right, Judge, because Churchill says it's dispositive, therefore it's dispositive because they stipulate it's dispositive. So, yeah, for the purposes here, if you win, because the state has committed to it being dispositive, they can't go back and say, well, we've changed our mind, let's go to trial.
Correct.
Which is,
And I don't think they've raised that issue. I understand.
no, I know.
The court's
but
questioning
I mean,
about it
it
today.
is the lay of the land right now, and it certainly doesn't seem like it was a dispositive motion. I mean, it certainly, I want to suppress this evidence because I don't think it should be admissible, or maybe the seizure, I guess the seizing of him maybe is the argument. You shouldn't have seized him because you had no probable cause. You, the arresting officers, had no reason to seize him. Maybe that's it. Not sure, but that's an academic discussion, though, isn't it?
Yes. And
Good academic discussion, but
yes, but I agree with the court's proposition that I think they're bound by having stipulated it was dispositive. But even if somehow I was wrong about that and you found otherwise and were willing to grant relief to my client, I would ask that, it be sent back with the trial court being ordered to enter an order granting the motion to suppress. But the relief we asked for is that he be discharged, and I think that's the appropriate relief based on this record.
Yeah, I mean, if it's reversible error because the state stipulated below it was a dispositive motion, then there's nothing further by law that they can do regarding the prosecution of this client regarding this incident.
Not to my knowledge, no.
Right.
With regard to the Montez Valaton issue specifically, again, it is our position that it requires more than what we had on this record. And I understand that there's some prior 5th DCA cases that indicate, and there's a case for the Smith case that the state, or excuse me, appellee cited from the 3rd DCA, that they predate Montez Valaton. Bowers predates Montez
They predate
Valaton.
Bowers, too.
They predate Bowers. Bowers predates Montez Valaton by 5 years, I believe. Bowers is also, and I know the appellee focused on it in their answer brief, but Bowers, to me, seems, there's discussion, but it seems to be more that the holding is relative to whether or not the fellow officer rule is an evidentiary, changes the evidentiary standard for the admissibility of hearsay in the context of a suppression hearing. I think Montez Valaton is more appropriately on par with this case based on the fact that there's just a lack of communication that would be sufficient and would provide probable cause or reasonable suspicion to Detective Platter, who de facto arrested or seized my client and then obviously searched shortly thereafter.
You're in your rebuttal time. I mean, you
I will
keep
reserve
going
my
if you
time.
want, but, okay.
Thank you. No, I'll reserve my time.
May it please the court, my name is Kaylee Tapman on behalf of the state of Florida. The trial court properly...
You agree this was not a dispositive motion, right?
Yes, but
You're
I
stuck with
understand
it,
we're bound,
right?
yes.
Okay.
The trial court properly denied the motion pursuant to the fellow officer rule. I believe that there was more than generalized communication here. Everyone knew that they were there to meet a traveler that was to arrive at a designated time with possibly out-of-state, vehicle tags who matched the photograph that they were given. It appears that this court is well familiar with the state's position. If there are
the general allegation or the general comments are that here's a picture. I mean, that in and of itself wouldn't be enough, right? I want you to arrest. If Steiner said, here's a picture of a guy I want you to arrest, that wouldn't be enough, would it?
That would be a directed, he would be directing a different officer to do so.
Yeah, I mean, I guess
Sure.
Following up your opponent's argument, yeah, if Steiner says, I've got a guy who I have probable cause who committed a crime, here's his picture, please go arrest him, that would tend to fall in the general. I mean, I know the fellow officer rule, the flow of the information that's imputed to the officers in the chain, I get all that. But I mean, what your opponent's argument is, there has to be something more than just, here's a picture, trust me, I got probable cause, go arrest him.
Sure.
Or here's a picture and he's going to be driving this white vehicle with a plate.
Sure.
Okay, but all right, so we're getting, I get to, since it's my conducting of the show here.
Absolutely. But here,
It's the term traveler.
correct.
It kind of, I guess, takes it past the, if I just said, please arrest this guy in a white car and he looks like this, there probably should be a little bit more. But when I say he's a traveler to the group of officers who are in that unit that arrests people who travel to have sex with minors, that takes a different connotation. That's more than just a general comment, I guess, is your scenario. It's a direct order that comes within the Montez case.
Correct. Here, it's the use of the word traveler, as Platter testified, traveling charge. Everyone knew what that meant. Everyone in the unit worked on these cases day in, day out. They had all conducted many and been the extras on over 100 Detective Platter testified to. And so they all knew that we're here to arrest a traveler. They also knew in this context that the generalized way these investigations worked, it was that after the undercover officer had probable cause, he would run it by Sergeant Kennedy, who would agree, and if Sergeant Kennedy agreed that there was probable cause, that's when they would set up this meet. So by Sergeant Kennedy and Detective Steiner saying, hey, we're going to go arrest this traveler, they kind of knew that someone had already, at least 2 people had reviewed it and believed that there was probable cause to arrest said
Just
person.
out of a curiosity standpoint, I guess, as you have 17 minutes, when you or your office leaves an oral argument like this, where you understand what, the issue being raised and the extension or non-extension of this doctrine, do y'all ever go to the prosecutors, the state attorneys, and say, not for nothing, if you want to make our jobs easier as the appellee on these cases, could you please tell your officers when you have a scenario saying, he's a traveler because he was online with me and I was posing as a 14-year-old and he said he wanted to have sex with me? Do you ever act, you decide what you want to decide, but that would seem to, your opponent correctly concedes that if your Steiner would have said that, then we really wouldn't be, I guess we theoretically could have an argument, but she wouldn't have a very compelling argument. And I'm not saying who's going to win here, but I'm just saying her argument certainly would tie up looser ends here.
Absolutely.
Now, so do y'all go say stuff like that to the prosecutors, saying,
I think we do sometimes. We used to have little seminars on various topics throughout the state. I don't know that we've done that in a while. I will happily call this prosecutor after this OA if you'd like.
I'm not saying how the state ought to do their job better, but I think your opponent makes a valid point, saying if this is the rules we have to live by, that's directed by Supreme Court precedent or whatever, and that's certainly their prerogative to set the precedent as they seem constitutionally appropriate in various factual scenarios, that it ought to be clear for everybody, and so that you don't have these discussions that when somebody is being arrested, the person who's arresting them knows exactly why they're arresting him instead of you're a traveler. And I'm not saying, I get that the people did the arrest, they understand the term traveler, they're in that division of arresting people who travel first to have sex with them. I get all that,
Yeah.
and I understand the arguments from both sides. I'm just curious that, this is, just like the scenarios we're dealing with in the Erlinger world of, say, can you all just have when you're having your trials with PRRs or HFOs, just have a jury, have the jury trial after the end of the trial saying, okay.
Yes, those discussions have definitely been had.
And that would satisfy the constitutional concerns being expressed by defendants in cases, as opposed to the arguments that I'm sure your side is seeing on a regular basis, or maybe not, because they may become pro, so you guys just decline to file briefs or something, but we certainly see them. But yeah, it's just, I always just my own curiosity of, when things are being brought, validly brought to the attention of the state by defense counsel like we have here, do y'all ever go talk and say, maybe we should give this some second thought?
Yeah, that has happened, and if there are any other questions, I'll rely on my brief and ask that you affirm. Thanks.
Thank you.
You'd like them to go tell the...
Yes, and I think it's in the record that Detective Steiner said that after this incident that they started doing things this is more of a general statement, but that they started doing things, I don't want to misstate what he said, but yeah, I think he said more precise. There was 2 issues. One was about getting the videos from the Wawa, and then the other was, I think in the context of this argument, that they're a little more thorough in their communications. I don't think he said it quite like that, but I think that's what he meant.
It's not like they're reading a Shakespearean novel. They just have to say what we've talked about.
I think it takes 5 seconds.
5 seconds. Here's why I want you to arrest
Yeah.
this traveler. This is what he did, and this is what. And I've talked to Kennedy, our sergeant, and here's the picture. That's the guy.
And I think it's important here because the court brought up that there was, or I'm sorry, appellee brought up that there was 2 individuals. There's Steiner, and he goes to Kennedy and he has Kennedy look at it. But absent that communication from Kennedy or Steiner to these other individuals, I just don't think it's enough. And I think that if we were talking about a warrant, we wouldn't be having this discussion because we'd have a neutral magistrate who had looked over it and decided, hey, there's probable cause, so then it wouldn't matter.
Would have been, because you
Right.
correctly agreed.
Absolutely. And if they'd done that, you know, it wouldn't matter who served the warrant, you know, like they could know nothing about it, you know, they're just out there serving the warrant. And then that makes the police officers' jobs easier to some extent. I know it doesn't make it easier when they have to go get a warrant necessarily, but, and I get that it's difficult in a situation like this, and I think that's why this case is a little bit
Timing
unique.
is harder to get a warrant here.
Right.
But you got to find a
Absolutely.
judge to.
They don't have probable cause unless he shows up, you know, like, so really there isn't, I understand. I just think in this situation, when they do so many of these operations, which I work in Seminole County, they do a lot of them. I understand that. I think it's important they do the work. But I think that, you know, it's a de minimis ask for them to make sure that the officers who are taking actions and arresting people and seizing people have the probable cause,
Well,
especially when
so-
we have no warrant. you
So
know?
is that your position, that the officer who actually puts the cuffs on, says stop, puts the cuffs on, he has to have probable cause? Because that seems to be inconsistent with the fellow officer role. Because I'm looking at, you know, Montez Valaton, and it talks about, you know, basically no communication. And here, the record seems to support that Officer Platter was told, we have a traveler and who's going to meet at the Wawa, but that he also used his other knowledge about his work, that he knew that Officer Steiner posed as a 13 or 14-year-old girl, that traveler meant the crime of traveling to meet a minor. And he also, I think, said that, you know, he knew that it was of a sexual nature because of the work that they're doing. So what more
I just think
did
there's a
Officer
lot-
Platter
Sorry,
have
I
to have?
interrupted you.
No,
I'm
it's
sorry.
okay.
I think there's a lot of assumptions there. Okay, just because they all do the work and they're all in a close room together and they all do this stuff doesn't mean that what's in one person's brain about this defendant is in everybody's brain. But I think that you know, there in Montez Valaton even, it seems like Molina, who's the law enforcement officer who ultimately gets the blood draw, you know, that he already knew that Montez Valaton was driving, someone died, you know, and that he's being investigated for this crime, you know. So I actually think even in Montez Valaton, there may have even, you know, there was a lot there. I think that it would have been arguably easy for the Florida Supreme Court in Montez Valaton to have just said, okay, well, what Molina had was enough. You know, it's not appropriate to suppress this blood draw. They didn't do that. I think they didn't do it for a reason, because they're requiring more. You know, they're requiring some communication. Again, I understand all this magic words, mentions in SAMs and whatever else, and I don't think it's magic words to just say, you know, what Judge Lambert and I discussed, you know, that it's just, I've been talking to this guy, I'm posing as a 14-year-old, he's talking about sex stuff with me, and he wants to meet up with me to have sex. I think that that's what should be required constitutionally. And I thank you for your time.
Thank you. Thank you. Very well argued case, and we will stand in recess.